नमस्ते, कंपनी 360 के यूट्यूब चैनल में आपका स्वागत है और आज की वीडियो का टॉपिक है सेक्शन 8 रिक्वायरमेंट्स फॉर द इंडियन पेटेंट एक्ट। इंडियन पेटेंट्स एक्ट और पेटेंट रूल्स के अंतर्गत बहुत सारे रिक्वायरमेंट्स हैं जो एक एप्लीकेंट को कंप्लाई करने होते हैं। वन सच रिक्वायरमेंट इज दैट ऑफ फाइलिंग अ स्टेटमेंट एज पर द प्रोविजंस ऑफ द सेक्शन 8 क्लॉज 1 ऑफ द पेटेंट एक्ट and rules 12 clause 1 and clause 1a of the patent rules setting out detailed particulars of corresponding application or applications in form 3. Section 8 clause 1 of the Indian Patents Act को देखते हैं। Section 8 of the Indian Patents Act 1970 mandates an applicant to furnish information and undertaking regarding foreign applications. इस सेक्शन की पहली प्रोविजन यह मेंशन की गई है where an applicant is prosecuting an application for a patent in any country outside India in respect of the same or substantially the same invention, he shall file along with his application or subsequently within the prescribed period as the controller may allow. A statement of setting out detailed particulars of such application. Accordingly, as per Part A, when an applicant enters the national phase in India either through Patent Cooperation Treaty (PCT) or through Paris Convention, there arises an obligation to disclose details of such foreign applications that have been filed before filing of the Indian application by way of Form 3, including in the patent schedule. अगर कोई एप्लीकेंट ऐसे डिटेल्स डिस्क्लोज करने में फेल हो जाते हैं तो उन्हें ये करने के लिए एक 6 महीने का टाइम फ्रेम दिया जाता है जो इंडिया में फाइल करने की डेट से शुरू होता है। इस टाइमलाइन को एक रिक्वेस्ट के द्वारा 1 महीने के लिए बढ़ाया भी जा सकता है। सबसेक्शन 1 का पार्ट बी ये स्टेट करता है एन अंडरटेकिंग up to the date of grant of patent in India, he would keep the controller informed in writing from time to time of detailed particulars as required under clause A in respect to every other application relating to the same or substantially the same invention, if any, filed in any other country outside India subsequently to the filing of the statement referred to in the aforesaid clause within the prescribed time. As per provision B, the applicant is obligated under the date of grant to furnish detailed particulars of any corresponding foreign application filed for some or substantially same inventions. Such details need to be furnished before the Indian Patent Office within the prescribed time of 6 months from the filing in the respective countries. However, the provision still leaves a room for interpretation because of the language of the said provision, which states, "He shall file along with his application or subsequently within the prescribed period as the controller may allow." ऐसा ऑब्जर्व किया गया है कि कुछ कंट्रोलर्स इस 6 महीने के टाइम फ्रेम के ऊपर एक रिजिड स्टैंड रखते हैं, जबकि कुछ कंट्रोलर्स इसको लेकर बहुत लीनियंट होते हैं। इन द लैटर केस, द कंट्रोलर्स अलाउ द फाइलिंग ऑफ फॉर्म 3 within 6 months of filing the application in India, irrespective of the fact that one or more corresponding application was filed to the filing of the Indian application. However, if an applicant furnishes the detailed particulars of existing foreign application details within 6 months of filing Indian application, some of the controllers might consider this an irregularity and may arise such an objection at the time of issuance of the examination report or during the hearing. To overcome the objection, the applicants have to file a petition under Rule 137 requesting to obviate this irregularity. Although such practice from the Patent Office is not common and merely appears to be monetary driven, but there have been a few cases where applicants have encountered such rare scenarios. आगे पेटेंट एक्ट और पेटेंट रूल्स ने सेम और सब्सटैंशियली सेम इन्वेंशंस इस फ्रेज को डिफाइन नहीं किया है। Therefore, before filing the details pertaining to corresponding applications, it is crucial to identify the corresponding applications in relation to the newly filed application. Typically, Paris Convention or PCT national stage family members applications sharing a common priority date, continuation applications, divisional applications, and continuation in part application can be considered as corresponding applications. Additionally, whenever an applicant discloses the details of corresponding foreign applications, they do include the status updates of such patent applications in their respective countries. For example, the status may include that the patent may be filed, pending, or issued in any jurisdiction. Examination report may be issued, etc. Although such status need not be updated from time to time, as only the disclosure of the foreign application is sufficient as per the Patents Act. But this scenario carries an exception too when it comes to controller's perspective. First exception, a few controllers tend to interpret that whenever there is a change in the status of corresponding foreign application, the applicant must provide updated details through Form 3 within 6 months of such update. In case of failure, the controller may raise an objection in FER or hearing notice issued afterwards, and the applicant is then required to file a petition under Rule 137, requesting to obviate this irregularity. It is pertinent to note that this approach is less common and opted by minority of controllers. अब दूसरे एक्सेप्शन को देखते हैं। कुछ कंट्रीज हैं जो यूरोपियन पेटेंट ऑर्गेनाइजेशन के मेंबर होते हैं। When an applicant files an application with EPO, they also designate some nations where they might get their patent validated after patent is granted by the EPO. Generally, the controllers do not consider an irregularity if the applicant has already disclosed the details of EP application with prescribed time, that is, 6 months from the filing of the new application or from the filing of corresponding application, even if the updates from the designated countries are not disclosed within the time limit. However, a few controllers ask the applicant to furnish information of the patent applications in the EPO member states within 6 months of time period of respective validations and may consider this an irregularity if the same is not done. अब हम इंडियन पेटेंट्स एक्ट के सेक्शन 8 क्लॉज 2 को देखते हैं। At any time after an application for patent is filed in India until the grant of a patent or refusal to the grant of a patent made thereon, the controller may also require the applicant to furnish details relating to the processing of the application in a country outside India, and in that event, the applicant shall furnish to the controller information available to him within such period as may be prescribed. The subsection 2 mandates an applicant to file the search and examination reports along with the granted claims for all the corresponding applications, such as revisional, continuation part, etc., for the same or substantially same invention that are filed outside India. This includes office actions, notices of allowances, grant decisions or refusal decisions, granted or allowed claims, all in English language whenever they are in any foreign language. ये बात नोट करना बहुत ज़रूरी है कि जो ये डॉक्यूमेंट्स मेंशन किए गए हैं वो वॉलंटरीली सबमिट करने की कोई ज़रूरत नहीं होती है, लेकिन पेटेंट ऑफिस से इन्विटेशन मिलने के बाद इसे 6 महीने के अंतर्गत फाइल किया जाता है। FER को इशू करते समय इन डॉक्यूमेंट्स की मांग करना पेटेंट ऑफिस की एक कॉमन प्रैक्टिस है। सेक्शन 8 सबसेक्शन 2 के डॉक्यूमेंट्स एप्लीकेंट अपने खुद के विश से भी फाइल कर सकते हैं। Practically, the applicant can consider filing the section 8 subsection 2 information along with the response to the FER within 6 months of the date of the FER or within the first month of seeking extension of the time under Rule 138. If the said documents are not filed within the stipulated time period or if extension under Rule 138 is requested but the compliance is not made within the extended period, the applicant for a patent can at any time before the grant of a patent request the controller to condone such irregularity in procedure by filing a petition under Rule 137 of the Patents Rules 2003. In recent times, it has been observed that ever since the Indian Patent Office became a participating office both as providing and assessing office in the WIPO case, the requirements for inviting the documents under Section 8, Subsection 2 have been reduced to a considerable extent. In the times to come, we might observe that the Indian Patent Office may lessen or not invite the applicant to file the information regarding the processing of the foreign applications that are a part of the PCT. The obligations under Section 8, Subsection 1 are mandatory on the applicant if there are same or substantially same foreign applications being filed. On the contrary, the obligations under Section 8, Subsection 2 arise when the controller raises an objection in this regard and asks the applicant to furnish said details. जैसा कि मैंने पहले बताया, कंट्रोलर्स इन प्रोविजंस को इंटरप्रेट करने के लिए अलग अलग अप्रोचेस ले सकते हैं। However, it is open for the agents to present their understanding and contest the objections in line with the most reasonable interpretations of the extant laws. तो इसी के साथ ये वीडियो समाप्त होता है। अगर आपको इस विषय के बारे में और जानकारी चाहिए तो आप हमारी वेबसाइट को भेज दे सकते हैं या यहाँ दिए गए ईमेल या फ़ोन नंबर से हमसे जुड़ सकते हैं। इस वीडियो को देखने के लिए मेरी और कंपनी 360 की ओर से धन्यवाद।